thank you all for joining us today. My name is Dustin Saldarriaga, and I'm an immigration attorney with Scott Legal PC. Today, we're going to spend some time talking about the EB-2 National Interest Waiver, or NIW, and this is a green card. It's an underutilized category and one that we've actually been seeing being used much more often, especially by entrepreneurs. Today, we're very fortunate to have my colleague Jiyae Hwang speak with us. Jiyae is a senior associate at the firm, and she has a great amount of experience preparing these petitions. A few things before we get started. Our firm is a full-service immigration firm, and so though we do focus on business immigration, we also handle family immigration, we handle humanitarian immigration, and really everything in between. So don't hesitate to reach out to us if you have any questions regarding U.S. immigration at all. This webinar is part of a series. We try to do at least 2 presentations a month, oftentimes more than that. So after this presentation, you'll receive an email, and in that email, you'll see a link where you can sign up for our future webinars. So we do hope that you sign up. We'll also share with you an NIW guide. This is a comprehensive guide to the National Interest Waiver, as well as the PowerPoint presentation that you see on your screen. The email that you receive will also have a link to our YouTube channel, and we post a variety of videos to our YouTube channel, both shorter videos on a range of topics, as well as the recording of all of our webinars. So this webinar is being recorded, and you can find the full recordings, as I mentioned, on our YouTube channel, so do check that out. If you have a question during the presentation, please do send it in through the Q&A function or through chat, the chat function on Zoom. I'll be actively monitoring those, and we do plan to get through all of the questions by the end of the presentation. So without further ado, I'm very happy to pass it off to Jiyae.
All right, thank you so much, Dustin, and hello, everyone. Welcome to our presentation. So why don't we start with the basic requirements on how to qualify for the National Interest Waiver green card. So as many of you may know, the NIW is short for National Interest Waiver, and it is a subset of the EB-2 employment-based immigrant petition category. And immigrant petition means that this is an application for a green card, U.S. permanent resident status. A green card gives someone the ability to live permanently in the United States and work for any employer or not at all. And having a green card also opens up the pathway to U.S. citizenship. So this could have great value for some people. Now, EB-2 NIW is a popular choice among individuals who want to apply for a green card on their own, and this is called self-petitioning. And this means you can apply as an individual, whereas normally you would need a U.S. company to sponsor you for a green card, and that could, take more effort and time, and you do need to have that employer who is willing to sponsor you. But EB-2 NIW does not require that. You can act as your own petitioner. EB-1A, Extraordinary Ability Green Card, is another category that allows self-petitioning, and we do also have dedicated webinars on that one as well. Now, the EB-2 NIW is attractive because this can be a viable option for a wide variety of professionals, including entrepreneurs, who can show that their work will make significant contributions to the industry, their field, or to the society as a whole to meet the requirement for national importance. Now then, let's look at the eligibility criteria in a little bit more detail. So first, you do need to meet the threshold requirement to qualify under the EB-2 category. And the way to meet this threshold is either to show that you have an advanced degree or that you have exceptional ability in your field of endeavor. So let's unpack that a little bit. So what does it mean by an advanced degree? Advanced degree means a master's degree or higher, and this would also include degrees like a JD, an MD, or MBA, for which you already need a bachelor's degree to apply for admission. You can also be considered that you have the equivalent of a master's degree if you have a bachelor's degree in your field and you have 5 or more years of progressive work experience that is full-time in your field following your bachelor's degree. Now, what does progressive work experience mean? Progressive work means that your duties and responsibilities have changed over time to increase in complexity and increase in seniority. And this can be shown by a change in title. For example, you would start off as a junior associate and then you would become a senior associate. Or your job duties have changed to include more senior responsibilities and supervisory roles. And also your salaries could have changed over time gradually as the years went by. So all of these details are relevant in proving that your work experience was progressive. Now, how do you prove that you have over 5 years of progressive work experience? You would do this by getting employment confirmation letters from your previous employers. And this should be signed by the relevant HR professional or your supervisor at your previous firm. And this would confirm the period of work completed, the terms of your employment, and detail your duties and responsibilities. And they should clearly show that those responsibilities changed over time. Now then, let's look at the alternative way you can meet the advanced degree threshold, the EB2 threshold, which is through showing exceptional ability in the sciences, arts, or business. And it is a two-step inquiry to meet this criteria. And the first is that you need to show evidence, at least 3 out of the 7 criteria that the government lists here. So for example, you could show an official academic record of any degree in your field, even if it's not a bachelor's or a master's that is relevant to your profession. You can show that you have a license to practice in your field. You can show that you have at least 10 years of full-time work experience in your field. You can show that you have a membership in professional associations in your occupation. And also you can show that you have received recognition for your significant contributions to your field by government agencies, by your peers, by professional organizations. And this could be in the form of, media awards, or if you have authored any intellectual property, such as publications or patents, those can also be considered forms of recognition of the value of your work. So cumulatively, all of these evidences taken together must show that you do have a degree of expertise that is, and I quote, significantly above that ordinarily encountered in the sciences, arts, or business. And an expertise that is significantly above that is ordinarily encountered is definitely a lower standard than what is asked in the EB1A context, extraordinary ability, the small percentage of people who have reached the very top of their field. That's the language that you use for the EB1A. But for exceptional ability, for the EB2 threshold is much lower than that. You just need to show that you are operating significantly above the level of expertise that is ordinarily encountered. Now, let's say that you have met the EB2 threshold criteria through either showing that you have an advanced degree or by showing that you have exceptional ability. The next step, and this arguably is the major part of any NIW petition, is that showing that you meet the 3 matter of DANISR factors that go into whether someone is qualified for a national interest waiver itself. Because the national interest waiver really is an exceptional benefit that is given normally in the EB2 criteria. The majority of the petitions are employer sponsored. So you do need a sponsor to qualify for an employment-based green card. But if you qualify for the NIW, you're exempt from that normal requirement. So the way to show that you merit this exemption, you would need to meet the matter of DANISR criteria, as I will explain. So the first matter of DANISR criteria is that your proposed endeavor in the United States has both substantial merit and national importance. And what does this mean? So substantial merit can be proven in a range of fields, including the arts, sciences, business, and even culture. And national importance means that the impact of your work will not only benefit your immediate customers, your immediate clients, but your work will actually have national or even global implications in your particular field. such as medical advances or improved manufacturing processes, and also significantly contribute to a matter that the US government may think has national importance and is strategically important for the nation. Now, what do you mean by that you are well positioned to advance the proposed endeavor? So this is a second criteria that matter of Danis are promulgated, and the focus of this criteria is on the individual themselves and their education, experience, and the particular skills that they have that positions them well to advance this work that is in the national interest. So, for example, you would show that you have a relevant degree. You would show that you have worked in similar projects in the past that has had successful results and have, attracted attention from industry actors, government actors. You would really want to show a track record of success in that field to really show that you are well positioned to advance your endeavor. Now, the third requirement and third and last requirement in the matter of Danis or factors is that on balance, it should be beneficial to the United States to waive the labor certification for your particular case. And we can argue this in a variety of ways. One way we could do this is really focus on the benefits of your proposed work, really arguing that the proposed work will benefit the industry as a whole, and the innovations that you are offering to the field has benefits that will be broad enough to outweigh the ordinary benefits of the labor certification process, which is to protect the U.S. labor supply for one more worker. Another way for entrepreneurs to argue to meet the third prong is that really show that your business endeavor in the United States will result in a high number of U.S. jobs being created. And that is a countervailing interest and an alternative way to, advance the Congress's intent to protect the labor supply. So you could persuasively argue that allowing, you to come to the United States and advance your business endeavor and create even more jobs in the process will be better for that policy. And one thing to note here is that all three factors must be met for you to be found to qualify for a national interest waiver. So even if you meet prong 3, if you haven't met prong 1 or prong 2, unfortunately, that will mean the national interest waiver application will fail.
Great. And Jiyae, a couple of questions came in that are relevant to this slide. The first is, do you know whether honorary degrees would count as an advanced degree?
Honorary degrees.
And I have thoughts on this if
yeah, do you have the answer to that, Dustin?
So I don't have the answer, but I would say if your honorary degree is from a foreign country, you're going to need an equivalency certification. So you'll need to go through a third party that will actually certify what the equivalent degree in the US is. And if the equivalent degree in the US is not a bachelor's or master's, I would say you're going to have problems qualifying based on that degree. If the honorary degree is from within the US, I think it's a different question and one that we'd need to do some research on.
Yeah, thank you, Dustin.
Sure. And then,
let's see another question here.
Yes. So, Jiyae, is there any kind of nationality limit? So someone from Pakistan, could they apply for an EB2 NIW?
There is no nationality restriction for the EB2 green card NIW.
Perfect. Okay, and let's save the remaining questions actually for later in the presentation, because I think you'll actually touch on elements of them as we move forward. So let's go ahead to this next slide.
All right, sounds good. Okay, so let's discuss a little bit then on how the national interest waiver visa option can be used for entrepreneurs. Now, what happened with the recent change in the case law that matter of Danis I've mentioned before, is that now the criteria national importance is understood a little differently than it used to in the past. So in the past, there was a previous case for eligibility on the standards of how to determine eligibility for the NIW, and there was a standard that you should meet national in scope. But now the focus has moved away from geographic scope of, your business activities or your proposed endeavor, what have you. So even endeavors with a new standard, even endeavors that are focused on one geographic area could meet the national importance criteria, depending on what the national interest is. So for example, let's say you are an entrepreneur and you're bringing in a large-scale development project, significantly contributing to revitalizing a particular economically depressed area, right? Let's say, and this is a specific county in a state that is flagged as one with high unemployment rates, depressed real estate prices, etc. And let's say that it is an important consideration for that region to really make sure this region is vitalized. And if you are working in partnership with that government agency, for example, to bring in this large-scale development project, and if you can prove that you will be generating many U.S. jobs in the process and will be hiring a high portion of the working population in that particular region, that kind of endeavor could certainly be found to have national importance under the new standards. So it really expands the variety of endeavors that can potentially qualify to have national importance. Another way you could show national importance of your endeavor is to show that your particular endeavor will have a broad impact to your specific field. So, and this includes examples like medical advances in a particular field or advances to manufacturing practices in your particular sector. So, for example, if you are working in a specific branch of science or technology, and if you are proposing to engage in research and development activities that could introduce new discoveries that are scientifically important, even if it's for that one narrow field, that could qualify as endeavors that have national importance. And you no longer need to rely on geographic scope of your endeavor to prove that your work has national importance. Now, another way that the new standards could be favorable for entrepreneurs is that now the case law, matter of Danaher, specifically recognizes that a green card through NIW could be a good solution for entrepreneurs who cannot go through the ordinary labor certification process with a U.S. Sponsor. And the case law actually recognizes that many entrepreneurs have ownership interest in their company. And so it is often not possible to use the conventional employer sponsorship route to obtain a green card. And another issue is that entrepreneurs create dozens of jobs. So Congress's interest in making jobs available for U.S. workers through the labor certification may actually be served better by allowing the entrepreneur to come in and create a high number of jobs instead of being stymied to do this through the labor certification requirement. A third way that the National Interest Waiver could be a favorable option for entrepreneurs is that now, under the new standards, entrepreneurs are not expected to prove that their business will ultimately succeed. And the case law specifically recognizes that many entrepreneurial projects may eventually fail. And the standard is not whether the applicant will eventually succeed in realizing their business plans, but whether the applicant presents a plausible plan with a prospective impact that can rise to the level of national importance, and whether the applicant is well positioned to advance the endeavor. So the standard is not to prove that your entrepreneurial endeavor will more than likely succeed, but really to present an informed and plausible plan to reach those goals. All right, now then let's talk a little bit about some logistical considerations, such as timing and other strategic consideration when you are considering moving from a non-immigrant visa to an NIW. So it is worth noting that the green card application has two steps. The first step is the underlying petition, which is the I-140, which determines if you are eligible for the green card under the EB2 NIW category. And the second step is the actual application for the green card. Now let's talk a little bit about timing. So premium processing is now available for NIW applications. Once you file the I-140, an action from the government, which can be an approval, it can be an RFE, a request for evidence, or it can be a notice of intent to deny. If they have serious concerns of your petition, this will be rendered within 45 days. And in practice, we have been seeing decisions even faster than 45 days. Regular processing, if you don't use premium processing, usually the expected timelines for the decision or action on the I-140 is about 1 year. Let's talk a little bit about priority dates, and we will also talk a little bit in more detail, but just to let you know that the timing here could be complicated because the first step, the I-140 step, you could get a decision within 45 days, but that does not mean you could immediately apply for a green card based on that approval. So if the priority date for your category is backlogged, and for the EB2 NIW category for all countries it is currently backlogged, you also need to wait until the priority dates are current before you can go ahead and file the immigrant visa petition or the adjustment of status application, also called the I-485. Now, let's talk a little bit about underlying visa status and strategic considerations that stem from that. So it is important to note that filing the NIW I-140 is an application for an immigrant petition. So non-dual intent immigrant, non-immigrant visas can be difficult or sometimes impossible to renew once you file the I-140. And a good example is the TN visa. So the TN visa is one category that is strictly assessed for immigrant intent. So the timing can be really important consideration if you are exploring the EB2 NIW option. If you maybe it is a safer choice to renew your TN visa first and then apply for the I-140, because having filed the I-140 could impact your future applications for the TN visa. And so in another example, let's say if your E2 visa is expiring this year and you also want to apply for an NIW, perhaps it is strategically a better choice to renew your E2 visa first. And once you have, let's say, an additional 5-year visa there, then you can apply for the NIW instead of having the NIW filed first and have that potentially affect your E2 visa application. Now, let's talk a little bit about the application process. So as I mentioned before, the green card application is done through 2 steps. So the first step is the I-140. You would submit the I-140 with all of the proofs that you meet the eligibility criteria, EB2 qualifications, as I went over before. And if there is an immigrant visa available in that category, so that means the priority dates are current, and you can, go look at the visa bulletin that is published every month. And if it says C, that means it's current. So if it says C at that point in time when you are applying, you can actually also simultaneously apply for your I-485 if you're already in the United States, which is the adjustment of status application. And let's talk about the second step, I-485 green card, and the timings for that. The I-485 is the adjustment of status application to become a green card holder based on your approval, the I-140, and the adjudication time depends on the specific consulate, depends on the specific service center that you apply to. And usually we've been seeing it takes at least a year to get the I-485 decision. So in consular processing consular processing means that you would apply for an immigrant visa instead of applying in the United States to adjust your status. That can also take many months, depending on the particular consulate's workload. So when you're thinking about applying for the NIW green card, definitely take it in mind that there could be multiple steps to that, and that could elongate the processing time period that's required until you have the green card in hand. Now let's talk a little bit more about the category being current. So So for EB to NIWs, this has only become an issue since the end of 2022. Every year, basically, there is a limit of the number of green cards that can be issued under each category. So except for certain countries, the EB to NIW has usually been current, which means there has been more visas available than there were people who were qualified and applying for the visa. But recently, actually, this category has been oversubscribed for all countries, which means more people are approved for the NIW and applying for the green card than there are green cards available each year. So, for example, the September 2023 visa bulletin says an applicant who filed their application earlier than July 2022 can now move forward to a green card. And this date has been moving forward recently from time to time, and every October a new batch of visas become available because October is the start of the new fiscal year for the US government. So we do think it is likely that there will be changes to the situation. But as of now, what this means for you practically is that even after your I-140 is approved, there may be a waiting period before the applicant can move forward with their green card application. Now, before we move on, let's talk a little bit about the differences between adjusting status in the United States versus consular processing. As I alluded to before, adjusting status is filing the I-485. This allows applicants to continue living in the United States and assuming they're already in the United States in a different non-immigrant status. While the I-485 is pending, the applicants are allowed to remain in the United States at that time. So a very important thing to note, and I've already touched on this, but you can only file the I-485 if you're already in the United States in valid non-immigrant visa status, and your priority date has to be current by the time you file. And this is important because just by filing the I-140 does not provide any status in the United States, right? And this is a common misconception. You can only continue to remain in the US after your I-485 adjustment of status has been filed while it is pending. Now, one important consideration to note is once you file the I-485, you cannot travel outside the United States without abandoning your application unless you also apply for and receive an advance parole document, which is a travel authorization document. And using that, you can travel in and out. But there is a little bit of a delay until you get the travel authorization document. So if you feel that you need to travel in and out of the United States frequently, filing the I-485 may not be the best option for you. And so now let's talk a little bit about the other option, which is applying for the immigrant visa through consular processing. Now, consular processing allows you to travel back and forth and in and out of the US and maintain your underlying non-immigrant visa status. And this could be an advantageous option if you need to preserve the ability to travel internationally until your green card process is complete. But the disadvantage of this is that this does not give you the independent basis to continue remaining in the United States. So you will need to maintain a different non-immigrant status, such as an H-1B visa, for example, to continue to work and live in the United States until your green card processing is complete.
Great. And so, Jiyae, a few questions have come in about the logistics and
Sure.
the visas being current. So one question that we can touch on very quickly is that the green card is issued based on your country of birth. It is not issued based on your country of citizenship. So that is the first thing to know. When you're looking at the visa bulletin and you see it broken down by specific countries, look at your country of birth. Now, Jiyae, what is the quickest you've seen a decision made after filing premium processing?
I believe that was 7 days for the I-140. That was
perfect.
Yeah, quite unexpected. But and it was an approval.
Great. And then of course the next step is the I-485, which I think you explained really well. Someone's asking in online forums, they've seen It can take a long time for an EB2 NIW, which you've clearly alluded to. It could take 16 to 20 months according to visa bulletins. Do you have any additional thoughts or comments on that?
So I'm wondering if this question is referring to the priority date backlog or the processing time for the I-485. So those are two different things, right? I would say the processing time for the I-485 stage, once you file it, usually the average would be about a year. You would expect to hear something in a year. But let's talk about the backlog right now, right? According to the visa bulletin. For that, yes, right now for September 2023, only if you filed your application. So only if your priority date is before July 2022, you can file, you can move forward with the visa. But we do think that this will change once the new batch of visas become available in October. So if I may, my personal prediction would be, by the end of this year, maybe we would start seeing really like the backlog being caught up to so that it becomes back to normal again. But this really depends on the volume of application and how many applicants the government approves in a certain given period. So unfortunately it's impossible to give very much informed predictions. But I do think things will start moving forward a little bit quicker once the new batch of visas become available. And I think it is a positive direction that we have been seeing the priority dates move quite quickly forward. For example, last month, the priority date moved compared to last month, the priority dates moved forward by 3 months. And the month before that also was 3 months back. So we have been seeing a little bit more accelerated movement in the priority dates threshold. So I think that is certainly a positive sign.
Perfect. Thank you.
All right, so let's now talk a little bit about, and shifting gears a little bit, talk about the updated guidelines which were published in the beginning of 2022 for STEM, science, technology, engineering, mathematics professionals, and entrepreneurs. So there were specific guidelines for both. So with regards to professionals in STEM, one thing to note is that the government published a list of critically important areas of technology that could be relevant in deciding whether a person's endeavor is in the national interest or not. And so the critical and emerging technologies, some of this include, and I will read from the list, advanced computing, advanced engineering materials, advanced manufacturing, advanced sensing, aero engine technology, agricultural technology, artificial intelligence, AI, autonomous systems, machine learning, biotechnologies, communication and networking technologies such as 5G network technology, data science, data storage technologies, energy-related technologies, medical and public health technologies, quantum science, semiconductors, and space technology is in the list. So if your proposed endeavor is within those areas, and if a part of your proposed endeavor is participating in research and development that proposes to advance the current status quo of these technologies, that is certainly something that the government will look at very favorably in adjudicating your NIW petition. And it is more helpful if you have an advanced degree that is in that area of expertise, such as a PhD in quantum science, for example. That would clearly be relevant to that favorable determination. So that is something to keep note. In entrepreneur-specific guidelines, now we have very helpful suggestions from the government on what kinds of special evidence that entrepreneurs can rely on to support their NIW case. So, for example, you can support that your endeavor has substantial merit and national importance if you can bring in significant media attention, for example, on yourself, your business, or both, and your name doesn't have to be mentioned if it is your company that received this media attention, if you can show that you have received awards or grants from government entities. And what is interesting here is that even some forms of investment could be taken as a validation of the merit of your endeavor, if it is from a major venture capital firm, for example, or a known accelerator or incubator in the industry. Those types of arrangements can also serve as evidence of the merit of your proposed endeavor. It doesn't need to be, traditional forms of evidence such as patents or publications. You can rely on those industry-specific forms of evidence. In addition, if you can show that you have been running your company and you have shown that you have raised revenues and significant growth and job creation, that history can also be used to support the fact that you're well positioned to continue growing your business. So your past business performance can also be pulled in as relevant evidence for an entrepreneur. Other examples of the entrepreneur-specific evidences we can rely on, as I mentioned before, proof of incubator admission, proof of accelerator participation, that can serve as an independent third-party validation of the merit of your work, and also the fact that you are well positioned to do this endeavor if you have been the one who is participating in such programs. If the company has published intellectual property, such as patents, even if you yourself are not named on the patent, you can still use such intellectual property as proof of potential impact of the work that your company has to do. So that is certainly a favorable aspect when you're preparing an NIW case for an entrepreneur. Letters from third-party reviewers, and this can take the form of industry professionals such as leaders of venture capital firms or leaders of notable incubators or accelerators. So it doesn't have to be in the academic sense. You can also rely on expert letters from relevant industry professionals in your field. All right. So then now let's shift gears, talk a little bit about the nuts and bolts of the documents that are typically involved in an NIW submission. So an NIW submission should first include that you meet evidence that you meet one of the threshold requirements, the threshold requirement for the EB2 classification. And as I mentioned before, you can meet this by either showing that you have an advanced degree relevant to your proposed endeavor, or that by you have exceptional ability in your area. And if you're meeting the criteria through advanced degree, you would want to show the diploma that you've earned for that advanced degree, and also perhaps include a transcript. And Dustin has alluded to this before, but if your degree is not from a U.S. institution, you should get a report from one of the accredited evaluation companies that perform these evaluations, and they would give you the analysis whether your degree is actually equivalent to a U.S. degree in that particular level. So if you have a master's degree from somewhere, you would ask the agency to give you a report that confirms that it is equivalent to a master's degree in the U.S. in that particular field. So you do need to have that report, in addition to showing your degree and showing your diploma and your transcript. So that is certainly an important point to make. If you are meeting the threshold through having a bachelor's and 5 years of experience in your field, so first, make sure that if you have a foreign bachelor's, make sure you do have that U.S. degree equivalency as you start. And on top of that, you want to get letters from your previous employers that show that you have 5 years of progressive full-time work experience in your field after you got your bachelor's. And all of these letters should be on company letterhead, signed by the appropriate individual, and contain the right details on what your duties were and how your duties changed, to make the case that your duties have changed over time to become more senior, more complex, to meet the progressive work experience requirement. And if you are meeting this threshold through exceptional ability, as I mentioned before, you want to provide evidence of at least 3 out of the 7 criteria that the government lays out in the regulations, and also make sure that those evidences taken in totality show the case that you are operating at a level significantly above that is ordinarily encountered in the field. Now, the major part of an NIW submission will be evidence to support that you meet all 3 prongs of the matter of Danazar test. And that would be, as I mentioned before, first, that your work has substantial merit and national importance. Second, that you yourself are well positioned to advance this endeavor. And third, that granting the National Interest Waiver will be beneficial in balance to the United States because of those reasons that we talked about. So let's talk about some relevant forms of evidence you could use. So news articles, academic papers, market research, that would really be background information to support your claim of how your impact will be, how the impact of your work will be broad enough to meet the requirement for national importance. And for entrepreneurs, it is very common to have a business plan and other evidence to demonstrate the economic impact of your work. And if you can show that your work will have a substantial positive economic impact to the region or to a particular county that is economically depressed, for example, that can be very positive for your application. And so in that business plan, you would include an explanation, a detailed explanation of what your offerings to the market will be, how that offering would improve upon existing products or existing approaches in the market, how your work will be disseminated not only to your clients, immediate client base, but how can this impact be result in advancing the field as a whole. So if you're engaging in conferences and making presentations about those innovations, if you're publishing intellectual property such as patents of your new innovations, so all of these things are relevant evidence on that can show the government what the potential impact of your work will be. Expert letters. Expert letters are another major part of an NIW application, and they really play the role of contextualizing all of the objective evidence and building the narrative of why your work is important and what the impact of your work will be. So these letters can be used to demonstrate substantial merit. This can also be used to really pull out case studies from your previous work to show that you are well positioned to advance the endeavor. The government will really want to know, they would really want to learn what have you done in the past and what has the impact of your work been in the past. And those stories can be built not only by your statement of proposed endeavor, but these experts can lend a testimonial to your previous work in the form of, explaining the most salient achievements that you've made in your field in a couple of paragraphs. That can really be a powerful form of evidence that can really contextualize your background and your case for the examiner. So expert letters play a very important role. What about the applicant's resume, degrees, proof of professional accomplishments? And this can include objective evidence such as patents published in the past. If you have made presentations at conferences, we would want to get copies of programs that featuring you. So not only is the narration built by the expert letters, we also use objective evidence to back up those stories that you pull out in the expert letters. And this can take the evidence, and this can take the form of, even internal reports that you have authored in companies, for example, if that was eventually tied to a product that was commercialized. You can build the case of your role in it by pulling the records from that you have generated in your previous position and tying that in with, media reports of the eventual product that was released or things like that. So there is a lot of room to be creative on how to build the data that can show the government that you've done impactful work before in your field. And this can really be tailored to the person's individual circumstances. So now, before moving on, let's talk a little bit about some particular forms of evidence that could be relevant for entrepreneurs. And this can include contracts with major firms, or if you work with governmental agencies, you could maybe have a contract with the governmental agencies. All of those objective proofs we would want to include as proof that your work has had traction in the industry, has had traction in the field, and as proof that people are interested in seeing you drive this project forward. And this can also take the form of letters of intent. And if you have received venture capital investment, you would want to show proof of that as well. This can be in the form of stock purchase agreements, or even if it's an incubator admission with an offer, you can include a letter from the incubator as well. So a variety of evidences that could go in an NIW case. And we really want to make sure that there is enough objective evidence in addition to the expert letters to show that there is traction for your project.
Great. And Jiyae, a couple questions are relevant to what you're talking about on this slide. First, a relatively broad question. How do you find expression of interest from U.S. businesses or companies that prove that the chosen endeavor has national importance, particularly given that it can be difficult to do pre-market research? How do you usually see clients navigating that?
Right. Expressions of interest from U.S. businesses or companies to prove that the chosen endeavors has national importance. I would certainly recommend that you would maybe start with leveraging your networks to even get in conversations with interested parties that could be potentially interested. And even if you have copies of LinkedIn messages that you've exchanged with some potential investors or potential partners in the project, having that record of communication can really show a possibility that there is some interest in the field. If there is no evidence at all of any US-based, individuals or companies being interested, then that could be a little tough, right? Because then how else would you prove that your work will have a broad impact in the US industry or the US field? So you could reach out to, if you're operating in a particular industry, there will be, there will be already a professional association or other professionals who are leaders in that field who are active in the United States. I would definitely recommend getting in touch with at least one person who can speak to the potential impact in the United States.
Great. And then relatedly, you've talked about documentation that you need to show ability. So is that an or when you talk about, all the examples of how you show ability to qualify for an NIW, is it that you need examples of all of those things, or is it one thing, two? How do you think about that?
So is it
So when we're talking about publications, citations,
right?
memberships, peer review, speaking. Is that an and or is that an or? And
I see,
how
I
many,
see.
yeah.
I understand the question. So if you can show as many as possible of those forms of evidences, that would be great. That it is not a you don't need to have every single thing that we list as possible forms of evidence, right? It could be that it could be that you have one or two of those categories of evidences, but you don't have the rest. In that case, we would really play to your strength and really emphasize the evidences that you do have. And this would really take different forms based on the individual client circumstances. Sometimes the strongest evidence is that this person's venture has been accepted in, Y Combinator or Techstars. Maybe that's the leading evidence that we go with, but that person does not have any patents, any publications, or anything. That should be fine, because really it's about the quality of the evidence, not only about the quantity of the evidence, right? So we really want, what we do when we sign up for a case is that really talk to the client and get a comprehensive understanding of the client's track record. And we would then be able to identify what are the most compelling pieces of evidence that they already have that can support national importance, a broad impact, and their exceptional abilities, right? So definitely those kinds of types of evidence that we talk about are suggestions, and they can be thought of as examples, but it is certainly not a checklist where you need to have everything in order to qualify for the NIW.
Perfect. So at this point, why don't we switch to an example, a case study, and then for those of you who are attending, this will be our last slide. So feel free to send in any questions you have, and then we'll wrap up by answering those questions.
All right. Thank you, Dustin. So yeah, let's talk about a case study, an example. And this is from an AAO case, an appeals case that was ultimately approved. So in this case, the applicant was an entrepreneur who formed a small consulting firm. And that consulting firm focused on doing projects with philanthropy organizations and governmental organizations in the area of veteran service. So the purpose of this person's business was to coordinate projects to improve the services and programs provided to returning veterans, wounded veterans who wanted to get back involved with productive society, right? So the proposal was to coordinate these projects with these relevant organizations, focusing on facilitating the reintegration of those veterans with productive job opportunities. So let's talk a little bit about substantial merit and national importance. How did this person meet that requirement? So the business plan included letters from prospective clients, and those letters and the examples in the business plan really described in detail how this person's business will improve existing program offerings in the United States. So you would recognize the limitations of the services that are currently offered and talk about what can be done to increase the effectiveness of these programs to really do things better than they are presently being done, right? And the real powerful thing about this application was that the person was able to get letters of support from these client organizations that described an intent to work with this person to provide those programming services. In addition, the file also included government reports, news articles, and also other expert letters from relevant leaders in the industry that really confirmed that this was a pressing problem for the United States and that there was a national interest in, really solving the problem of, returning veterans having trouble being effectively reintegrated into society. So having that objective evidence in addition to the letters was quite helpful in this case. And then now let's talk about the second prong. Proving that the person is well positioned to advance the proposed endeavor. So in this case, the entrepreneur had a very salient success record in past endeavors in the UK where he was from. And this person included testimonial letters from senior government officials in the UK talking about the projects which he has led before that were very similar to the proposed endeavors that he was outlining in the business plan, which actually had on-the-ground impact on, connecting service members to productive work opportunities. And some of these projects have been very large scale. So, for example, this person's work has resulted in enabling millions of dollars of charitable funding being productively connected with these initiatives in that area. And that kind of record of success really painted him as someone who has an advanced degree of experience and insight and networking in this area that could really help bring the field forward. So because of these supporting letters, the business plan was very credible, right? So supported by the evidence of multiple correspondence with potential clients and potential partners and business financial statements that show that he had enough startup capital to really make this plan a reality. So that was a big part of supporting prong 1 and prong 2 of national interest waiver factors. Now, let's talk about the third factor then, on balance, beneficial to the United States to waive the labor certification requirement. How did he meet that requirement? So the first thing to note is that the government had to already find that he met prong 1 and prong 2 even to get to prong 3, right? So now, once we got to prong 3, the discussion was really about being an entrepreneur. This person will be self-employed, so it will be impractical to obtain a green card through the traditional labor certification process, right? And the government really focused on the immense value, the broad impact, the importance that this particular project would have to U.S. governmental interests, right? So improving programs and assisting organizations that support the welfare of U.S. veterans and wounded warriors, there was no question that the value of this to the United States was very important. Finally, past record of success and the fact that his services were demanded by potential high-profile clients in the United States really helped bolster the fact that the U.S. would benefit from this person's particular experiences and unique abilities rather than, this person being replaced by just another person with similar minimum credentials in the United States.
Perfect. Thank you, Jiyae. So we have reached the end of our presentation, the question and answers part. A number of great questions have already come in, and we actually only have one outstanding, which is, can you apply for an EB-2 NIW as an attorney?
So the answer is yes. So if you are an attorney, right, and let's say you have a JD degree from a U.S. law school, that certainly, puts you as a advanced degree professional, and you could use that. But the important thing is really to prove that your work, proposed endeavor in the United States will have national importance, right? And that is certainly the question there. Let's say if your work is limited to providing great legal services to your immediate clients, then I would say that is a tough, difficult case to qualify for an NIW, because what the NIW is looking for is a broader impact than that. So in addition to helping your clients achieve great outcomes, what can you do to the legal industry as a whole, right? So can you, think of a new way to interpret a certain piece of legislation, and has your work, been presented to other attorneys through, being active in conferences, for example, if you, research a paper and then you publish it in a legal journal, for example, and has that been cited by many different attorneys? That kind of public-facing work, that can be disseminated to other experts, I think would be the focus of the inquiry here, right? On whether the impact of your work goes beyond your immediate employer, goes beyond, just benefiting your clients. So I would say it will depend on how much activity you have and what kind of evidence you can provide to show that your work will have a broader impact than that. So if you have much experience there, then definitely we can consider the NIW. If not, then it could be a matter of working towards those evidences. So I would recommend having those evidences, objective evidences of your participation in those conferences, your publications in relevant industry journals to support your case for national importance.
Great, that's really helpful. So Jiyae, no other questions have come in. Thank you so much for sharing your expertise with us today. And to the audience, thank you so much for the active participation and the great questions. A number of questions came in that were really specific to your backgrounds, your qualifications. So for those, we really don't use webinars to get into the details of specific cases. So reach out to us, schedule a consultation. We'd be very happy to talk through that with you. And keep an eye out for the email that you will receive soon. Sign up for future webinars, check out our YouTube channel, and as always, reach out for anything you need. Jiyae, thank you again. And to our participants, thank you for taking the time to join us today. Have a great day.
Thank you, Dustin. Thank you, everyone.